Today is Saturday, June 25th. It's official. The U.S. Supreme Court released its ruling yesterday that effectively overturns Roe v. Wade, which had for nearly 50 years guaranteed a woman's right to an abortion. Now it'll be up to the states to decide whether to ban or restrict abortions. We've been expecting this decision ever since a draft opinion was leaked back in May. But today we're asking what happens next. One legal expert tells us she expects chaos and confusion and says it's already apparent in states like Texas. Attorney Greer Donley, an assistant professor at the University of Pittsburgh School of Law, is sharing the potential legal consequences of this Supreme Court ruling. She recently co-authored a paper published in the Columbia Law Review specifically about this topic called The New Abortion Battleground. And later, we get the response and reaction from the president of Texas Right to Life, who also has his doctorate in bioethics and health policy, Dr. John Seago. A quick note that we spoke with both guests shortly before the final Supreme Court decision was announced. So now, let's get into it. Welcome to the Newsworthy Special Edition Saturday, when we sit down with a different expert or celebrity every Saturday to talk about something in the news. Don't forget to tune in every Monday through Friday for our regular episodes, where we provide all the day's news in 10 minutes. I'm Erica Mandy. It's now time for today's Special Edition Saturday. Greer Donley, thank you so much for coming on the Newsworthy.
I'm happy to be here.
So first, let's just start by helping everyone understand why now? Why is this time in this case different than previous cases dating all the way back to Roe v. Wade?
So Roe versus Wade has had a target on its back ever since the decision came down in 1973. But every time that the Supreme Court was asked to reconsider the fundamental holding from Roe versus Wade, it has upheld the constitutional right to have a pre-viability abortion. So the reason why this case is different is that it totally overturns Roe versus Wade. We are expecting that roughly half the country will ban abortion, and we will be living in a country where, half of Americans are in a state where they might not have access to any legal abortion at all.
And let's clear up a common question. If the Supreme Court does ultimately decide to overturn Roe versus Wade, that does not mean abortion is illegal nationwide. It means it's up to the state, right?
You're exactly right. This would go back to a state-by-state decision. I think the thing that's really important for people to recognize about that is that it's going to create chaos. Every state is going to have a completely different abortion law on its books. And so, the thing with the federal constitutional right to abortion, it created kind of a national floor that ensured some consistency across state lines. But what we're looking at in the future is actually a very, very complex web of different types of laws. My co-authors and I, David Cohen and Rachel Ray Boucher, have written a paper arguing that anti-abortion states are very likely to try to actually chill folks from traveling to get an abortion, or perhaps will try to prosecute abortion providers that are located outside of their states, creating more uncertainty.
So what you're saying is that a woman who wants to travel to a different state for an abortion could face legal consequences from the state she lives in for doing that. Is that constitutional?
Most Americans assume that we have, a right to travel in this country. And, if you look at other types of kind of moral crimes like gambling and marijuana, people freely travel between the states to take part in something that their home state might have banned. There's just very, very little case law actually suggesting that that is a right. And there's a lot of uncertainty within those laws. The Post-Roe future will involve a really complex analysis of trying to figure out if you are at risk when you travel, but also in the context of personhood, people should be nervous about what it would mean if your state declares a fetus a person under the Constitution or under the laws of that state, what that means if someone leaves the state to have an abortion because of the consequences that could come from that determination.
And with today's technology, it's even more complex, right? Because maybe not everyone realizes that FDA-approved pills for abortion can be sent to patients in the mail. And it's my understanding that some of the medications are also used for miscarriages, right? So does that get murky?
Oh, it gets so murky. And one of the things that I want to really highlight to people is that it is not just abortion care that we're going to start seeing be really difficult to access in a post-Roe world. It is also pregnancy loss treatment. For the same drugs and procedures that are used for abortion are the exact same drugs and procedures that are used for miscarriage. and occasionally for stillbirth as well. We are already seeing the effects of this in Texas, where pharmacies are refusing to fill prescriptions for people that are experiencing miscarriage because they are the same drugs used for abortion, and the pharmacy cannot confirm whether or not the patient is using it for an abortion or a miscarriage. And so folks are having a really hard time accessing that medication already. Similarly, we're already seeing that there are patients in Texas that are having a hard time getting access to treatment for ectopic pregnancy, which is a life-threatening, non-viable pregnancy. There's been reports of people having to travel out of state, even though that is a medical emergency that could turn dire at any moment because they are being refused abortion care. Same is true for folks who are experiencing very premature labor before a fetus is viable. Oftentimes, the only way to treat or to stabilize that imminent pregnancy loss is with an abortion, and folks are being forced to travel out of state. So it is certainly not true that the only people who are going to be affected by these laws are those who want to end a pregnancy. It is also people who are carrying wanted pregnancies and that are suffering from pregnancy loss.
How does privacy factor into this debate? Because aren't patients and doctors protected by HIPAA regulations?
So HIPAA in general protects people's private health information, but it has exceptions in the context of law enforcement. And so the ones that come up most frequently is there's an exception if there's mandatory reporting. So theoretically, a state could pass a law that requires hospital workers to report any suspected self-managed abortion. The second is that hospitals and healthcare providers are required to comply with any sort of subpoena or any sort of kind of official government document requesting information related to a crime. The third is that healthcare workers and hospitals and providers are allowed to disclose information to law enforcement if they think that there was a crime where a person was killed. And so obviously this comes into play in the context of a state that has a personhood law. And then the fourth is there's a potential exception to HIPAA if someone believes that a crime occurred on the hospital property.
Some critics worry that this potential decision could impact treatments like IVF, that those could be deemed illegal as well. So what do you think? And if so, how or why?
I don't think this decision, like on its face, is going to impact IVF. I think that what people mean by that is that this decision seems to open the door for personhood statutes. For instance, the law passed in Oklahoma declared that a embryo is a person from the moment of conception. And this particular law seemed to be restricted to pregnancy. But in the past, we've seen states try to pass personhood laws that are not restricted to pregnancy. And if it's not restricted to pregnancy and any embryo, fertilized egg or embryo is considered a person, then that has very serious implications for IVF and might even lead to IVF being essentially banned in a particular state.
Anything else that we haven't talked about that you think is important to mention, or just a final takeaway?
I think 50 years of precedent about a right that many people hold very dear is something that is a pretty significant thing to just take away overnight based on reliance. So reliance is the idea that average American women and pregnant people spent their lives relying on the fact that they could access abortion if they needed to, and that we can't just take that away from them. Justice Alito was quite flippant about that and said, no, there's no reliance here. I think that's not true.
Up next, our conversation with Texas Right to Life President Dr. John Seago. He weighs in on some of these big legal questions mentioned in the first half, including what the law in his state already says about providing certain medications to women experiencing a miscarriage, and whether the Supreme Court decision could impact fertility treatments like IVF. So here's our conversation. Dr. John Seago, thank you for coming on The Newsworthy.
Absolutely. Thanks for having me.
So assuming by the time this airs, Roe v. Wade is actually overturned, what is your reaction?
Yeah, this is a phenomenal success for the pro-life movement that's been, 50 years in the making. It's important that we realize that this is just the turning of the page into a new chapter. We still have a lot of work to do, and moments like this really kind of show you that there is so much more that we need to commit ourselves to.
So some critics have pointed to, and legal experts have pointed to, confusion that's already happening within some of the states like Texas, where some of these state laws exist. Is there concern that doctors may hesitate to act if they fear they'll get in trouble for performing an abortion, even if a mother's life is in danger?
Yes, that's a huge issue that we have to take very seriously. Unfortunately, there have been mischaracterizations of the law. The language of Texas law allows doctors to treat a miscarriage. It allows doctors to respond to an ectopic pregnancy. It's very clear, and it names those specifically, that is not considered an elective abortion. There are no prohibitions on that kind of treatment. And it also talks about medical emergency when the life of the mother or a major bodily function is jeopardized by the pregnancy, that the doctor is allowed to get involved. Now, unfortunately, there have been misunderstandings about this, but that's something that we have to clarify to our medical professionals, that we do not want to put them in a situation where they feel like they cannot appropriately respond to these dangerous situations.
Some miscarriage medications are the same as abortion medications that might be used for abortion. Some reports have said that pharmacies in Texas have been hesitant to provide some of these medications for miscarriages because of this anti-abortion law. So same thing, same response to this is a confusion that needs to be fixed?
Our law is very clear that if you are prescribing these drugs for other reasons, or if you are performing a surgery necessary to respond to a miscarriage, that is not an elective abortion. An elective abortion by Texas law is going out of your way and intentionally causing the death of the child. Even in most medical circumstances, that's not necessary. Maybe early induction or emergency C-section. These are more appropriate responses to these situations. You don't have to go out of your way to cause the death of the child, but that's what is defined as an abortion in Texas law. And unfortunately, some of our trade organizations that typically would clarify these types of things have been silent on this, possibly because it's a politically loaded issue. I'm not quite sure, but you're right that there has been misinformation and confusion around this. But we have to be very clear that the law explains what doctors can and cannot do. And it's the responsibility of their facilities, responsibility of trade organizations, and news outlets like this to really clarify what's allowed and what's not allowed.
So we've talked to a legal expert who said once every state has a different law in place, that it's going to cause so much confusion that it's essentially going to be chaos. Do you agree? How will this actually play out?
I mean, this is the nature of federalism. It is going to vary state by state, and it's just going to be the responsibility of our movement, the pro-life movement, and our medical professionals to be very clear about what state law is and what is allowed. I don't expect Congress, U.S. Congress, to make any progress on this issue anytime soon. And so, unfortunately, that is going to be the situation. And we're just going to have to do our best to make sure that our medical professionals are very clear on what they can do.
Do you think states should be able to restrict their citizens from traveling to a different state, a neighboring state, for an abortion?
I believe that, or I understand there are some debates about what states can do to stop providers from performing abortions on their citizens. I think that there are some legal, hurdles to those policies. From our organization's standpoint, though, rather than threatening making it criminal or civil liability, we want to make Texas an environment that doesn't, cause a woman to think it's in her best interest to travel outside the state. We want to create a pro-life state that is supportive, that is, has the resources available, and is clear in our communication to Texas women that if you are in an unexpected or difficult pregnancy, there are resources, there are organizations, there are programs that are here for you. That's the best response, in my opinion, of Texas for women that think they may need to travel outside the state.
The AP has reported that some district attorneys say they would not enforce anti-abortion laws. What happens then?
This is a problem because we have a law. The legislature is supposed to pass the laws, and the judiciary and law enforcement are supposed to enforce them. And so at the legislature, state legislature, we're looking at tools to go around district attorneys, allowing our attorney general, who's a statewide law enforcement officer, making sure that he has the authority to prosecute a crime, even in one of these districts, a DA is opposing it, or that we allow other district attorneys to come in and prosecute crimes if one fails to do their job.
There have also been some questions about the potential impact on IVF. Do you think that's something that could or should be banned in some state laws?
IVF is a completely different issue. IVF itself is not something that pro-lifers in the mainstream are trying to outlaw. What we are trying, where we do have concern is what is done with embryos that are not immediately used. Our principles in science affirm that the child, the embryo, is a unique human individual that deserves our moral attention and legal protection. But that is going to have to be a conversation for another time.
Any final thought or takeaway for our audience?
Hopefully we'll be, kind of an example for other pro-life states of what to do in a post-Roe world.
Well, thank you so much to both of our guests for sharing their insights and perspectives with us today. We will be covering more about the Supreme Court's official ruling during our regular news roundup this Monday, and we'll be bringing you any other updates as we learn them. So join us every Monday through Friday for our regular 10-minute news roundups. For now, thank you so much for listening. Share this episode if you found it helpful, and have a great weekend.